This is a Marshall Enterprises presentation. Peace, everybody. Welcome back. Welcome back. Welcome back. We're going to get right into this presentation today. And first and foremost, I have to give a big shout out to Mr. Unique, Mr. Levon Unique Richardson, for your kind words, your observations, your critiques, and your request. And it was your request that I do a part 2 to the ins and outs of the criminal justice system. And without further ado, I am going to provide what you requested. So let me share my screen and get cracking on some of the stuff that you requested. I can't do it all, and I'll show you why in a second, if I can actually move this stuff out the way and get to where I need to go. Okay, so we're going to start this presentation here. Don't know why my screen is pausing or is stalling. The window's not opening. I don't know why. Come on. Come on. I don't want a new window. I want the existing windows. Here we go. Okay, so when you go into a courtroom, you'll notice that the courtroom is set up a certain way. And it's basically set up as you see here. One of the things, or a few of the things that you always notice, is the judge's bench is where the judge's bench is. The defendants and the plaintiff's table is sometimes interchangeable because you might have the plaintiff on this side, defendant on this side. You might have the witness stand on this side, or the witness stand will be on this side. But everything else more or less is going to be about the same. The swinging door, they may have more than one, but generally it's right here in the middle. Now, why is it that new courts always resemble old courts? You'll walk into a brand new court and it looks like one that was from the 1920s or 1930s because of not tradition. They have to keep it uniform. It's about uniformity, and you're going to see that written in the laws that we're going to go through. All right, so that's why you would see courts set up this way. You also see churches set up in this particular manner. You know, you would have the pulpit. You would have the choir stand back here, something like that. You would definitely have the pulpit, not the pulpit, but the pews where the patrons sit. All right. And there's always a separation between these two areas. Also, just like the benches, the judge's bench and the judge's benches area is raised above the floor. You'll see how the pulpit in a church is raised above the floor. There's reasoning behind that, but I'm not going to make this video so deep to go into the meaning of those things, but you'll see that as we continue going, and there's a reason for that. So we knocked out the courtroom structure. We've knocked out the uniformity, how you're going to find this in all of the courts and things of that nature. So we're going to close it out. And I have a few pictures here I can show you. Courtrooms. You notice the judge's table back here, the witness stand, the plaintiff and the defendant, and the separation of the public and what's going on in the front. If we close this one out and go to another view, you see about the same here, how things are set up. All right. So it's uniformity. And again, they do this for a reason. All right. Now, while we're dealing with that, we have to deal with laws. The laws in which that we are following, that we are operating within today, are not new. These are generations and centuries old laws, statutes, canons. It's religious codes of which have been handed down and brought down for generations and centuries. So a lot of that stuff that we are being held accountable today, whereas the statutes, the codes, the ordinances, rules, and all of that thing, it comes from biblical times. It comes from the canons. And what is canons? Let's do that real fast. Canons. We did the courtroom. Let's get rid of that. Canon, we got rid of that. Canons in canon law. Let's go to the significance by Britannica. I didn't reread this, so canon law has to do with religion. Canon law, Latin jus, canonicum, body of laws made within certain Christian churches, Roman Catholic, Eastern Orthodox, independent churches of Eastern Christianity, and the Anglican communion by lawful ecclesiastic authority for the government both of the whole church and parts thereof, and the behavior and actions of individuals. And the wider sense of the term includes precepts of divine law, natural or positive law, incorporated in the canonical collections and codes. So this goes back a while. Although canon law is historically continuous from early church to the present, it has, as a result of the doctrinal and ecclesiastical schisms, developed differing, though often similar, patterns of codification and norms in the various churches that have incorporated into their ecclesiastical frameworks. The canon law of the Eastern and Western churches was much the same in form until these two groups of churches separated in the schisms of 1054. The Eastern Christianity, however, because of the doctrinal and nationalistic disputes during the 5th through the 7th century, several church groups, especially non-Greek, separated themselves from the nominal head of Eastern Christianity, the Patriarch of Constantinople, and developed their own bodies of canon law, often reflecting nationalistic concerns. I will not continue reading all of that, but this is giving you a breakdown historically of the canon laws, the canon rules, ecclesiastical doctrine, and what have you. And this is what makes up the body of laws, the body of language of which we utilize today in the laws, statutes, codes, and ordinances that are out there today. All right, so why am I going there? Let's kill this and go to canon, the 12 presumptions of court. I did a video on this. I'll definitely put a link up here so you can go into that. But basically, I want to scroll down to summonses because I particularly use this one to deal with parking tickets and summonses. And not only parking tickets, citations, and summonses, but when you get summoned to court, when you are they put out a, what do you call it for you? When you, I'll get it in a second. You're subpoenaed. The presumptions of summons is that by customs, a summons unrebutted stands, and therefore one who attends court is presumed to accept the position, defendant, juror, witness, and jurisdiction of the court. Attendance to the court is usually invitation by summons, unless the summons is rejected and returned, with the copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and position as the accused and existence of guilt stands. This, if you read it over and over and over, you may get an understanding of what is going on here and why I used it and why it's still in use today and why it still can be used today. All of these things have relevance. And if you don't know your history, you are doomed to repeat it. So those of you who do not have a firm or basic understanding of civics, then you will be bound or you will be taken advantage of by individuals, organizations that do know what you don't know. So you need to get a basic working understanding of the stuff, or get a firm understanding of the stuff. So those are the canons. Let me read you one more. Let's do the guardians. Number 7, the court of guardians. The presumption of court of guardians is the presumption that you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P. You are a pauper and therefore under the guardian powers of the government and its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter, the trust, before the court, the presumption stands and you are by default a pauper and lunatic, and therefore must obey the rules of the clerk of guardians, the clerk of magistrates of court. All right. This stuff means something. This stuff holds weight. You got to know what is going on in these courts, these tribunals, these hearings, and how they are affecting you. What does this have to do with anything? Well, we are, and where's that file at? We are doing part 2 of the ins and outs of the criminal justice system. And in the first video, I kind of explained to you where I'm going to use me and talk about me here. This is my out. This is my out. I've used this out on 2 occasions so far. But in the event that something happens, and let's say I get accused of a crime, and I go through these steps, once it get to this point where charges may be filed, this is where I head out of the system. If there is a chance that I may have to go up the river without a paddle, hopefully with one, then it goes to these areas, and then there are still defenses and things that can be done. Now, for the individual that saw part 1 and told me that this is not clear, it's blurry, and et cetera, I am going to scroll through this right now slowly so everyone can see exactly what is written here. And I'll continue in a second. This is the flow chart of the criminal justice system. This is the procedures of the criminal justice system. And let's go to the next level of information, from crime to these different points. I want you to be able to read all of this. And definitely, I will leave the link to this document in the description below. Feel free to pull this up yourself, look through it, get familiar with it. And in a second, I'll kind of advise you on the area in which you should concentrate. And I'll do that now for you. Where you should concentrate is the outs. If you are accused of a crime, suspected of a crime, and you go into these channels here, here is the out: unsolved or not arrested, release without prosecution, release without prosecution, charges dropped or dismissed, charges dropped or dismissed. There's other outs as we go up: refusal to indict. The grand jury didn't see fit to indict you, so you walk out the door in that one. You go here, the charges are dismissed. You get acquitted. Appeal. Habeas corpus. You get a pardon. You don't want capital punishment. You don't want that out. Now, going down into the misdemeanor section, you got charges dismissed. You got acquitted. You're going to have to do jail time, in out the system, perhaps, perhaps not. And This would be the juvenile section of the proceedings, and it would have you, and how they get out and released and diverted, would have you. But this is where you really need to concentrate your efforts, your energy, your education, how to deal with this, because all you need is a diversion by law enforcement, a diversion by the prosecutor, a diversion by the court, and you will be out of their system. All right. I hope you got that. We're going to close this out and move on. So now, again, this is part 2 of the ins and the outs of the criminal justice system. And I have some things that I would like to show you that I didn't mention or I touched upon in part 1, but I'm really going to go more into detail here. So let me close that window out. And we went through the canons. So remember, where the canons come from, what is it, the relevance to this all, and how it can be used to help you get out of the system, avoid the system. Now, as requested by a cousin of mine, Mr. Unique, he wanted some more information as far as the Uniform Commercial Code. But before I go there, let's go to 27 CFR Subsection 72.11. So I'm going to do a fresh search. Let's open up a new search column. We're going to do 27 CFR, which is right there, 72.11. Let's just click go. That's going to take us to the meaning of terms, or Freedom School does a little good section on it. But we're going to go to the first one that comes up, because on your computer, it may be the same thing. Let's go to the first one that comes up. 27 CFR, that's the Code of Federal Regulations, 72.11, the meaning of terms. Why are we here? We're going to go down to commercial crimes. Commercial crimes. Any of the following types of crimes, federal or state: offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and the like offenses, extortion, swindling, and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. Those are commercial crimes. So there is a term in the Uniform Commercial Code that states that all crimes are commercial. All crimes are commercial. There's something down here I wanted you to see as well. Equity director, contraband, agent, United States, agent, cigarettes holding, cigarettes, contraband. No, commercial crime. No. Okay. Now, what I did was, when I first read this, anytime you read something and you don't understand what you just read, you should look up those terms and make sure you get an understanding of what you're reading before you continue. So when we add commercial crimes, and it says any of the following types of crimes, federal or state: offenses against the revenue laws. Revenue laws, what the heck is that? Well, let's go do a search. Revenue law meanings is what I put in. I'm gonna click the search button again, so to just refresh, and you got revenue law legal definition. Well, for the sake of arguments, let's just go into there and see what that says. A law relating to the imposition or collection of taxes to defray the expenses of government. Okay, let's go back. Revenue legal definition. Revenue, define, or definition of revenue. Let's go into the law.com and see what they say. Revenue, as applied to the income of a government. It is a broad and general term, including all public monies which the state collects and receives from whatever source and in whatever manner. Okay, just reading some case law right here. It also designates the income of an individual or private corporation. Public revenue, the revenue of the government of the state or nation, sometimes perhaps that of a municipality. Revenue law, law which provides for the assessment and collection of a tax to defray the expenses of the government, is a revenue law. Such legislation is commonly referred under the general term revenue measures, and those measures include all the laws by which government provides means for meeting its expenditures. So that could be parking summonses, tickets, property taxes, you know, when they give you a fine for violating the ordinances where your trees can't be so high and so long, so big, your brushes and your lawn has to be mowed and the grass has to be clipped, etc. So violations of the revenue laws produces fines. If they're egregious, you might get jail time, but that is where revenue laws, and let's go back to 27 CFR, offenses against the revenue laws is considered a commercial crime. Okay, so I don't want to bring back up that chart. You know what? I'll bring it up right here. Nope, wrong one, right there. So all crimes are commercial. If all crimes are commercial, there has to be some type of remedy commercially to resolve a commercial crime. So what is another way that you can get an out of the system, which is not discussed, but privately we discuss? That thing is called arbitration. Arbitration. What in the hell is arbitration? So for that, we're going to go to Wikipedia, and I'm also going to go to a definition, or like a legal definition of it. So let's go into it right here. Arbitration, a form of alternative dispute resolution, is a way to resolve disputes outside of the courts. What did I say? Arbitration is a form of alternative dispute resolution, is a way to resolve disputes outside the courts. The disputes will be decided by one or more persons, the arbitrators, arbiters, or arbitral tribunal, which renders the arbitration award. An arbitration award is legally binding on both sides and enforceable in the courts. Here we go again. Well, let's go to the next paragraph. Arbitration is often used for the resolution of commercial disputes, particularly in the context of international commercial transactions. I'm going to stop there, and I'm going to stop there for a reason. Commercial disputes, and let's go back to 27 CFR, commercial crimes. This all ties in together. This all ties in together. Now, I want you to look these things up yourself, please. Commercial crimes, all crimes are commercial. Put that into your search column and see what comes out of that. Look up arbitration. Now, I want to do a search on arbitration and just get the definition, because we read it right there, arbitration definition. We read it, but some people don't really get it. But let's look at this here. Arbitration, the process by which the parties to a dispute submit their differences to the judgment of an impartial person or group appointed by mutual consent or statutory provision. The hearing and determining of a cause between parties in controversy by a person or persons chosen or agreed to by the parties. The hearing and determination of a cause between parties in controversy by a person or persons chosen by the parties. I mentioned in the last video, and I mentioned several times before, there is a reason why you don't see certain ethnicities or religious groups in prison or in jail. And a good reason, a great reason, a great deal of the reasoning behind it is due to arbitration. Because when two people have a dispute, you're going to need a referee or a judge to differentiate between the facts. If you would like to avoid the judge, you can go and have a jury, a party of your peers, a group of your peers, or you can have an arbitrator step in and decide the dispute. Now, let's roll back to landlord-tenant disputes. If you have ever gone to landlord-tenant court, most of the time, almost 99% of the time, you are there to attempt to get a stipulation. A stipulation is an agreement between the parties. You have to work out an agreement. It fails me to come to that religious text where it says agree with your adversaries before you come to court. I will make sure I will put that in here, right here, as I'm editing this video. Agree with thine adversary before you get to court. It's about an agreement. If you cannot reach an agreement, then you're going to need a referee, an arbitrator, a judge, or a jury. Most of the time, the only options that you are given is a judge or a jury. You don't know anything about an arbitrator, but that is one of your remedies. But that is only really spoken on the private side. What are you talking about, bud? Okay, let's continue. So we've seen 27 CFR 7211, where all crimes are commercial or commercial crimes and the definitions of those commercial crimes. So I'm going to close that window, and we're going through this pretty quickly. Arbitration, we read that. Let's close that. That is the flow chart. Now, when someone, either on the state or federal level, is found guilty of some type of charges, you look into their paperwork, you are going to find an interstate commerce charge associated with their charges. An interstate commerce charge. What is that? Okay. I see I didn't pull it up prior. I apologize. But again, private side information. There is an interstate commerce commission of which you can appeal to have your disputes resolved, because all crimes are commercial, and most of the time, 99% of the time, you are going to find an interstate commerce charge associated with any charge that you receive. 99.99% of the time, you are going to get an interstate commerce charge. And this is the Interstate Commerce Commission, of which I really wish you would look into. All right. I can do some reading, but I don't want to waste too much time on it. You know what? Let's just read a paragraph or two here in interstate commerce. In U.S. constitutional law, any commercial transactions or traffic that cross state boundaries or that involve more than one state. The traditional concept that the free flow of commerce between states should not be impeded has been used to affect a wide range of regulations, both federal and state. A further extension of the established notion regarding the free flow of trade was introduced when Title II or Title 11, I gotta know what title, I don't know what title, I think that's Title II, of the 1964 Civil Rights Act, dealing with discriminatory practices and public accommodations, was upheld by the Supreme Court. The court decided that a business, although operating within a single state, could affect interstate commerce with its restrictive laws and was therefore at odds with the federal legislation that proved to be enabling of the Constitution's Commerce Clause. Family. Let me take you in a different direction. We've looked up revenue. I'm going to close that window. We've looked up 7211, the commerce, that clause. Interstate commerce, we just read that. I would like to show you this here. President Trump exposed some information that normally goes unspoken. It's not really brought to the public's attention. And there is very good reason for these things. When you read certain laws and certain statutes, you read it and say, well, that's not what Bud said. This only has to do with this. It doesn't have to do with that. Okay, but when you look at the CARES Act, when you look at the Stimulus Act, let's pull up this act. Am I at the right area? Let me see if I'm at the right area. I am going to pull up the actual document. This is what they do with these bills. A bill is a set of documents with rules and regulations, and these things are a bill until the Senate passes it, the House passes it, and subsequently the president signs it. So these are bills until they become law. Once the president signs it, again, it becomes law. So in order for something, now the CARES Act and the stimulus bill, very, very, very controversial and very important legislation. There's a lot of people paying attention to it, and it has importance to it. And when these type of bills come up, what happens is the legislators, the representatives, they have pet projects that they want pushed. And they say, well, oh, if you want this bill passed, you're going to have to do something for me. Oh, you want to give the American people 600, 1,200, 4,000, whatever the money is. Oh, well, you got to do this for me and, you know, in return for my vote. So that is what is called pork. Donald Trump exposed this pork and said, no, take that back. I'm not going to sign it with this pork in the bill. But they've been doing this for centuries and aeons, and they're going to continue doing this because this is how bills get passed. You rub my back, I rub your back. So I want to jump down to page 1450 real fast and show you something about a law that was passed and you all agreed to. You know why you agreed to it? Because you're getting $600. You're getting $1,200. You're about to get $1,400. You don't care. You don't care about what is included in these things until someone brings it to your attention. We need to be reading these things and knowing what the hell our legislators, our representatives, our senators are actually passing, signing, introducing. Page 1450 of the CARES Act, although they call it something else. I'll give you the full name in a second. But we're going to go scrolling down to, where's it at? go to number 14, basing rights agreement. None of the funds appropriated or otherwise made available by this act may be used by the government of the United States to enter into a permanent basing rights agreement between the United States and Iraq. Jordan, of the funds appropriated by this act under Titles 3 and 4, not less than ones, tens, hundreds, thousands, 10,000, 100,000. That's 1 billion. Not less than 1 billion shall be made available for assistance to Jordan, of which not less than 845 billion, ones, tens, hundreds, thousands, 10,000, 100,000s, millions, 10 millions, 100 million, 845 million, okay, shall be made available for budget support for the government of Jordan. So $845 million shall be made available for the budget support for the government of Jordan. Not less than 10 million, ones, tens, 100,000, 10,000, 100,000, right? 10 million shall be made available for programs and activities for which the policy justification decisions shall be responsible, or should be the responsibility of the United States Chief of Mission in Jordan. So this is just one. Let's scroll down. Foreign Relations Act. Here's one for Lebanon. Funds appropriated by this act under the headings International Narcotics Control and Law Enforcement and Foreign Military Financing Programs that are made available for assistance for Lebanon may be made available for programs and equipment for the Lebanese International or Internal Security Forces and the Lebanese Armed Forces to address the security and stability requirements in areas affected by conflict in Syria. Now, ladies and gentlemen, what does this have to do with the coronavirus or your pandemic relief packages, your CARES Act relief packages? So they add these things to these bills because you want it passed. You're only thinking about that $1,200, that $600 that you're going to get. You're not thinking about this $845 million that's being sent to another country. This goes down for pages. The Lebanese government, what we have here, you have that's Lebanon there. Foreign Assistance Act, which country is this? Immigration Assistance, United Nations Facility and Department of State, Foreign Relations Appropriations. I'm reading Libya. This is for Libya. This is for Morocco. Foreign programs and assistance, fiscal year for Saudi Arabia. Why are we giving all this money to foreign nations and the American people, of which the taxpayers foot this bill? You're giving each American $600, but you're giving foreign countries millions. These are questions that you need to consider. But the reason I went here is when you go to a statute or you read something and you say, well, okay, that's not what it means. Understand that there are wording hidden within that law or that code or that bill that has nothing to do with the CARES Act, the coronavirus. It has nothing to do with it, but this is how they get information passed or get expenditures passed without people really knowing what's going on. And you have to do your own due diligence, or someone has to be a whistleblower and point these things out. So let's close that. I think we did that justice. Let's close out this link here, or I'm going to leave this for now. But we were talking about interstate commerce, and you'll say, okay, I read this and it only talks about nations and international nations. Okay, well, New York and New Jersey are two separate countries. But because of your lack of knowledge, your ignorance, you don't understand how these things are laid out, and this has to do with civics. So those are not just two states, they are also two separate countries. And technically, because they have their own constitution, their own military, etc., they can be considered two nations. But that's too big, and it's debatable and the whole nine. So let's scroll back and go back to originally what we're talking about here, the issue at hand. Let me pull up this here. Now, all crimes are commercial. If you don't already know by now that your country, your government is a corporation, it is a business. Your business is taking you to court. Your business is suing you in court. What are you talking about, bud? Okay, let's go straight to the Clearfield Doctrine. The Clearfield Doctrine states private commercial paper is used by corporate government. Then government loses its sovereignty status and becomes no different than a mere private corporation. So when a government uses private commercial paper, it in turn becomes a mere private corporation. So instead of being the United States government, it is now the U.S. corporation. And the U.S. corporation is now suing you. So let's go back to arbitration. Arbitration can be used in place of. So if you get sued or you get a commercial crime, or get charged with interstate commerce, it's commercial. It's commercial in nature. Who is bringing forth these charges? You have affected the revenue laws, or you have offended a statute, a code, or an ordinance of who? What? Of a corporation. It's not a government, it's a corporation. So the corporation is coming after you. So this, in case you're missing it, this is yet another out that the private side utilizes, because we totally understand that the government is a corporation. The corporation is coming after you, not the government. The corporation is coming after you, not the government. So there are ways that you can deal with the corporation. You can go through arbitration. You don't have to go to a court with a judge and be adjudicated and be sent to jail. You can go to arbitration, and either they award you a monetary award, or a monetary award is awarded to the corporation that is suing you. So you do not have to forfeit your body to stand in for these charges. Oh boy, this is so encompassing that it's difficult to actually articulate this any clearer. You'd have to ask a bunch of questions, and we'd have to go through the intricacies of what I am trying to parlay to you, although I think some people are getting this. So if the government is allegedly, or if the alleged government is only a mere corporation, according to the Clearfield Doctrine. Now, can you prove that the government is just a private corporation? Okay, according to the Clearfield Doctrine that you read right here, let's go see what private commercial paper is. When you type in, private commercial paper, and you look up what a private commercial paper is, it leads you to what I was asked to talk about in the first place, the Uniform Commercial Code. So commercial papers and the types of commercial papers. The UCC identifies 4 basic kinds of commercial paper: promissory notes, drafts. There's more down here, but promissory notes. A promissory note is a 2-party paper. The maker is an individual who promises to pay, while the payee or holder is a person to whom payment is promised. The payee can be either a specifically named individual or merely the bearer of the instrument who has it in his or her physical possession when he or she seeks to be paid according to its terms. A note payable to bearer can be paid to the person who represents or presents it for remuneration. Such an instrument is said to be bearer paper. The dollar bill, the United States notes, the paper that you have in your pocket, in your wallet, is a promissory note. It is commercial paper. The government prints this, the government issues this, the government accepts this. Let's go back to the Clearfield Doctrine. Private commercial paper is used by corporate government. Then government loses its sovereignty status. It becomes no different than a mere private corporation. Okay, that isn't clear. That isn't clear. Let's go into the Clearfield Doctrine itself. Did a video on this, and I think I'll add that link right here. And this is what was decided in a Supreme Court case. It was Clearfield Trust versus the United States. It says governments have descended to the level of mere private corporations. Clearfield Doctrine, Supreme Court Annotated Statute, Clearfield Trust Company versus the United States. Here's the case law where you can find it. Where it's defined pursuant to Supreme Court Annotated Statute, and here's the case law. Government descended to the level of a mere private corporation and taking on the characteristics of a mere private citizen, where private corporate commercial paper, Federal Reserve notes, and securities checks is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. This is a case that is a live, good case that can be used as reference, and is being used for reference all the time. So if you caught what was just said there, that means the private paper being used by that corporation, i.e. the United States, is just a private corporation that is suing you. You can opt for arbitration as opposed to jail time. If you get caught with a firearm, if you disregard the revenue laws, even taxes, failure to pay your taxes. Okay, let's go to arbitration. You don't have to go to a court of law. I think we're done with this. I can press the issue on and on and on, but I think you've merely got it. If you don't, ask me some questions. Follow up with me. Let me know if the presentation was to your liking or if it was not to your liking. Let me know if there's anything else that you want me to touch on. I was specifically supposed to go into the Uniform Commercial Code, but I chose to take this route to explain some things to now go into a part 3 and then go into Uniform Commercial Code, because you have to lay the groundwork to see where this is going. There is a private side to all of this, and that private side is you're out. If you remain in the public, you have to do what the public does to get free with the public. If you take yourself back into the private, there are private measures and remedies that are afforded to you if you know what they are and how to activate them. So there is always an out. There is always an out. This is Bud Brownsville, and I am out.